I can hear you. Let's see. Which feed should I use to hear you? I'm not on Facebook. I'm not on LinkedIn. All right. I'm gonna work on the computer screen. I'm ready.
I think they should have fixed it. Can you guys hear me and see me now? Can you hear me, see me well, please? If you can, please let me know you can hear me and see me well. I think I fixed the issue. I see what the issue was. Can you hear me, guys? On Facebook, YouTube, LinkedIn. Okay, great. They can. I think they can hear me now. I see some questions coming in. You guys start dropping your questions. It's fine. You're all welcome to today's live session. If you can hear me across platforms, please drop USA or an emoji of the US flag. Please, please. Thank you. Let's make sure that you can hear me. I understand I'm echoing on TikTok. Oh boy. Let's see. I think this should be fine now. Please confirm on TikTok if you can hear me and see me good. Today we're live with former immigration judge Judge Pappas. He's here. I'm going to bring him on Facebook momentarily. Let me just do some housekeeping matters. As you guys know, we decided that we're going to be doing immigration court series this year, at least once a month. Unfortunately, last month we couldn't have the series, and so we're having two this month, one at the beginning of the month and the other one at the end of the month of March. Okay, so that's what's going on. And Judge Pappas is a former immigration judge. He was let go last year by President Trump. You guys know many of the judges were let go. um the very nice, kind judges were let go, and there's a lot of controversy about that. But obviously, the immigration courts are now struggling. He is now telling us what goes on inside U.S. immigration courts, so that immigrants can know how to get themselves prepared before they get to immigration courts, because that's the final decider. As I always say, once you get to immigration court, you can either be deported or you can get a green card. Of course, you can file an appeal when you are deported, but it's a major game changer in the immigration court process. So you don't want to play with it. Now, let me just mention that before we begin today's discussion, I want to take a brief moment to celebrate Ghana, my home country. Woohoo! Because today we're celebrating Ghana's 69th independence anniversary. We're so excited. Apparently, Ghana became the first sub-Saharan African country to gain independence from colonial rule, the British. And so that was a moment that inspired freedom movement across the African continent. And as a Ghanaian born attorney who's practicing immigration law in the US, this day is really important. And we just want to take a moment to recognize Ghana, the country Ghana, and the beautiful people of Ghana across the world, in the United States and in Ghana. It's a day to remind us of our resilience, progress, and power of opportunity across countries, and of course, unity. So to everyone in Ghana, across the diaspora celebrating Ghana today, happy 69th Independence Day. All right. So let me bring Judge Pappas on. Okay. Very welcome to today's live session. How are you doing?
Hi, everybody. It's great to be.
Okay, great. Okay, great. Wonderful. Thank you so much for joining us. It's such a pleasure to have you back on here. We are so excited to have you on. Today we'll be talking, or we'll be looking at asylum. Guys, we have really interesting topics throughout the year, so you don't ever want to miss this once a month on Friday. Let's get started with today's session. So Judge Pappas, you're welcome again. Did you want to give any brief intro or say something before we get started or delve into asylum in immigration court today?
Well, asylum is a critical application for relief. And, all I can say is preparation is key, and making sure that your fear of persecution fits within the confines of asylum law. That's the trick. That's the challenge. And so making sure that you're walking down the right road illegally is critical. And I'll explain that in further detail as we go along. But most of the cases that I dealt with in immigration court were with asylum. And many of the countries that I dealt with from the African continent were, Congo, Angola, Cameroon. Those were the main three countries I dealt with. Of course, I dealt with the Central American countries. So I've had a lot of experience around the world with different kinds of relief. But we'll go into the details. And I look forward to answering the questions. So let's give it a go.
All right, great. Thank you so much. You guys, again, let me repeat. I can hear myself echoing. What's going on? Can you guys hear us really well? Okay, let's try again. Okay, this sounds good. Now, guys, this is a really rare opportunity for you to get insight. You guys know that this doesn't happen. A whole immigration judge, former immigration judge, he's here with us to tell you guys what they are looking out for and how to win your cases. So please don't take this for granted at all. Come with your questions and make sure you're sharing this live feed. There are people that need to hear this really important question. Right now, Judge Pappas, tell me about this. What does a judge look for first in an asylum case? And when you started, you mentioned, I'm sorry, there's a lot of echo. I'm not sure how we can resolve this. Maybe an echo. Yeah. Let me see this here. I'm sorry, guys. Hold on. Let's do something. Let's see. Okay. Still the same.
Do you want me to log off TikTok?
Yes, maybe we can try that. Yeah, let's try that and see if that will work.
All right, I'm off.
Okay, let me see. Oh, there's still the echo there.
That's strange.
Extremely. I'm not sure what we can do now. Let's see here. Okay. There's still a really bad echo. I don't. The thing is, I don't have a microphone, so I'm not sure why this is happening.
Let's see
Somebody,
how I sound. How do I sound? Okay.
hmm, you sound great. Do you
Okay.
hear? Yeah, your sound is fine. I'm not sure. Let me log off TikTok as well and come back. I don't know if it has to do with TikTok. Hello. There's still the echo.
A little bit.
Okay. Should we? Okay. Well, I won't be doing majority of the talking, so maybe we should go on so that we don't derail um the session. I'll just go on and hopefully it will resolve itself. Now, Judge Pappas, you mentioned as persecution when it comes to asylum. Please break it down. What does persecution even mean?
Persecution, according to international law and U.S. law, means that you have been harmed, whether through threats or physical harm, based upon your race, your nationality, your religion, your political opinion, or what the law describes as persecuted social group. Those are 5 categories. And if you fall into one of those 5 categories, you've started on the right road toward trying to prove your asylum case. If your harm does not fall in those 5 categories, you're not going to be covered under asylum law. So think of harm as a very wide avenue, a wide spectrum, but asylum is a very narrow part of that spectrum. So when you apply for asylum, you've got to fit in within the confines of asylum law. So that's the way to start the whole thing. And as a judge, the first thing I'm going to look for is to see whether the application, the I-589, talks about the type of harm that would be covered under asylum law. So that's my opening statement.
Thank you. This always reminds me that people who come and say, "Oh, I'm struggling in my home country, and so that's why I came to apply for asylum."
Well, if you use that as a basis for your asylum application, the chances of you being approved are virtually impossible. If you fear general crime, if you fear that there's no economic opportunity for you to get a job or to advance your career, and that's why you're coming to the United States, that's not going to work. Not because your fears and struggles are not real. It's because those types of fears and harm are not covered under asylum law. So fear of general crime, fear of lack of opportunity, it's not going to work. So if I see an application talking about that type of fear, I know from the get-go, not only is that claim not producing what we call in law a prima facie case for asylum, in other words, at least a minimum basis for qualifying for asylum, that's the perfect type of case or a file that would, under today's conditions, be denied without a hearing. That's exactly what these new judges are looking for. They're looking for claims that have absolutely no basis under asylum law. Those will typically now get knocked out without a final hearing.
Okay, sounds good. Now let's start from the beginning. How does someone find themselves? How does someone find themselves in immigration court, and how does that happen?
It happens in 2 ways. People approach the border, and they may go to a port of entry and speak to an immigration officer and say, "I'm seeking asylum in your country, and I want to apply for asylum." And typically, once the individual, not the lawyer, once the individual tells the Border Patrol agent that they seek asylum, they will be scheduled for a credible fear interview if it's the first time that they have approached the border. And at that interview, many questions will be asked about the person's fear. And if the asylum officer believes that they have answered a sufficient amount of information to qualify for a possible full hearing, they will let them into the country. That's called a credible fear interview. Another way to enter asylum proceedings in immigration court is someone who's entered the United States already. And perhaps they've been detained by ICE and they have no relief and they're ready to be deported. They can also announce their desire to seek asylum to the immigration officer. Again, they will have an opportunity to prove that. And if the officer believes they have a prima facie case, they will be allowed to enter removal proceedings before an immigration judge to apply for asylum. So those are two ways that an individual can enter using asylum in the immigration court process. And there's a third way. If you're in the country already and you're not in immigration court, you can apply for asylum before the United States Citizenship and Immigration Service. That kind of asylum is called affirmative asylum. The other types of asylum, when you're in immigration court, is called defensive asylum. So those are the three ways that you can apply for asylum in the United States.
Thank you, Judge Pappas. So the first thing is, what does a judge look for first in immigration court? And when somebody has an asylum application pending before court?
I didn't catch the whole question. Can you repeat it so I can hear it all?
Okay. Do you hear me still echoing?
A little bit in and out. I think for the most part, it's okay. Let's see if we can repeat that question.
Okay. What does a judge, an immigration judge, look for first in an asylum case?
The question is, what are one of the first things a judge looks for in an asylum case? The first thing I'm going to review in a file is the 589, the application for asylum, and I'm going to look for the reasons why the individual fears. I hope in that box where the person has checked yes, that they fear either that they suffered past persecution or future persecution, I want to see what details, what information they are showing as the basis for their fear. Was it based on their political beliefs? Was it based on their party membership, their religion, their nationality, their race, or some other factor? Once I read that, then I can see pretty quickly whether that person has an opportunity. After I see that they do have a possible opportunity, then I want to read the individual's declaration. I want to hear their statement. I want the details of what happened to them. So I'm going to read through that, and I'm going to look for details that show that their past harm or future fear is based on those protected areas covered by asylum law. And that would be a very good start. So those are the preliminary things I look for. Obviously, I'm going to look at country reports that talk about the kind of fear that the person is expressing. And of course, I'm going to look to see if there's any witnesses who've signed declarations. I'm going to see if there's any medical reports to document harm. I'm going to see if there's any police reports to see if the person reported any of these threats or harm to the police or local authorities. Those are some of the key things I'm going to look for at the very beginning. So those are my initial observations at the beginning.
Okay, great. Can you please rejoin TikTok? I think the sound is fine now.
All right, hold on.
Okay.
Bear with me.
Sure. Thank you. And let me ask this question. At what points do you look at the 1 year deadline rule, the 1 year filing deadline rule, while you're trying to join TikTok?
I'm going to look at the filing deadline at the very beginning. I want to know when that 589 was filed. I'm going to look at the notice to appear to see when the government alleges that the individual entered the United States. That's very important because that entry is when the clock starts on the 1 year deadline, because you have to file your asylum application, your 589, within 1 year of your last entry into the United States. So that's the first thing I'm going to look for. If there's evidence that they filed past the 1 year, then they're going to have to show why they may be entitled to a waiver. So these are all preliminary observations that we check off. One of the first things we check off was the application filed within 1 year? Yes or no? And that's even described in the 589. There's a question that says, did you file within 1 year? And if you say yes, great. If you file no, you need to explain in that application what prevented you from filing in 1 year. And I will tell you, if you say, well, I didn't know what the law was, so that's why I filed late, I can guarantee you that you will not get a waiver if you say, I didn't know the law. That is not going to work. We'll describe how you can get a waiver later on.
Okay, great. Thank you. Can we see your face on TikTok, please? And yes, you're right. Ignorance of the law is no excuse, because I always say, think about it. If everybody would say, "Oh, I didn't know," "Oh, I didn't know," then everybody could get away with virtually everything or anything. So, and it would be really hard for the judges to determine, well, did this person really know? Now have to go into the mind to figure out whether someone really knew or didn't know, and that would be so hard to determine. You are presumed to know. It's your duty. Law.
It's your obligation. Ignorance of the law is not an excuse. Just remember that.
Yeah, that's right. Okay. All right. Now, what makes a testimony believable from your
This
experience
is,
on the bench?
I can tell you, AK Poku, what makes your testimony believable is probably one of the most important things that you, as an asylee or an applicant for asylum, need to understand. Truthfulness is very important. 2, consistency of your testimony in court and what you wrote in your application is critical, because the Department of Homeland Security is looking to discredit you, is looking to challenge your credibility. If you testify to information that is inconsistent with your application, or if you testify that you don't know many things, not one or two, you're entitled to mistakes. You're entitled to forgetting things under the pressure of testimony. That's not going to hurt you. But if a pattern emerges where you're consistently misstating facts that you already filed in your own application, or if you can't remember what you filed in your own application, or 3, if your testimony is grossly inconsistent with your declaration, the one that you signed off on as being a sworn statement, if these statements or omissions are serious enough, your credibility will look bad. And as a judge, I want you to know, if we see significant inconsistencies, the court, the judge, has an obligation to let you know that we have a problem. Ma'am, sir, we have an inconsistency here. You said in 1970 you were employed at this factory, but you just testified that you were working in another country at this time. Can you explain that inconsistency? What's happening here is the court will give you, if they're following the law, an opportunity to explain the inconsistency. If your explanation is not plausible, if it's not logically sound, that will be noted by the judge and it will be used as a strike against you. Many times it requires several inconsistent statements or several omissions or a combination of both before the judge determines that your credibility deserves an adverse credibility finding. It's a fancy way of saying, we don't believe you, or it's a fancy way of saying, you're lying. If the judge finds that you have produced adverse credibility finding, your asylum application automatically will be denied. Okay? Then the only relief available to you will be what is called withholding of removal or the Convention Against Torture. So your credibility, the consistency of your testimony with your statements and declarations is so important. You need to prepare for your hearing by reviewing your own answers. It's embarrassing if you don't know what you wrote in your own 585 or your own declaration. Your attorney, if you have one, should be making sure that you do your homework. So that's my answer about how important credibility is in an immigration proceeding. Credibility could derail your entire application for asylum if it's bad enough.
Okay. Now, in your introduction, you mentioned something really important, that asylum could be based on persecution or a well-founded fear of persecution. First of all, if you can tell us the difference between those two concepts and what you need to prove. And then my next question would be in the individual protected grounds. We'll go through the 5 protected grounds, but let's start with the basis of the asylum.
The basic of asylum consists of 2 parts. Either you prove and show that you suffered persecution in the past, maybe as a child or as an adult, and you have to show that that past persecution was based on the protected grounds that I talked about. And you would then have to show that you were targeted, threatened, or physically harmed because of your religion or your political opinion or nationality. That's in the past. As a child or even as an adult, if your past persecution was so severe that even though you may be an adult now, and even though if you go back to your country now, you won't suffer the same kind of persecution you suffered in the past, but if it was severe enough, just the mere fact that you have to go back to your country is too traumatic because of the severity of the past persecution. Under those conditions, you will be granted what's called humanitarian asylum because your past persecution was so severe. Even though it's been years since you've been there, there's no way that psychologically, emotionally, that you can expect to be returned in a reasonable state of mind. So that's the past. If you cannot prove any past persecution, zero, you still can prevail with your asylum application if you can show that you have a well-founded fear of future persecution. And here you have to show again that your future fear is based on one of the protected grounds. And the way you prove this is not only your subjective fear, it's now important that you also prove your subjective fear is substantiated and corroborated with third-party evidence, country reports, expert testimony. And if those third-party documents or evidence substantiate and underscore your subjective fear to a reasonable degree, your fear has to be reasonable based on those protected grounds, then you can be granted asylum, even though you suffered no past persecution, because your well-founded fear has a reasonable possibility of happening and your subjective fear has been substantiated. So those are two ways that you can prevail with asylum. Now, going into the last question, AK Poku, that you asked, I think you wanted me to go into the details of the five categories.
Yes, I do. Let me just mention the grounds again here. So the grounds, you must show, persecution based on one of the five protected grounds: race, religion, nationality, political opinion, or membership in a particular social group. Can we take one after the other and then, just briefly discuss?
Let's go through them. The first four are easier to define than the last one. If you're a member of a church, if you're a member of a religious sect and you're being targeted or threatened because of your religion, that's a basis to try to claim asylum based on your religious beliefs or your religious affiliation. I'll leave it at that. Your race, you could be a member of a certain tribe. Your skin color could be identified as a particular race. You could be indigenous, and that race basis also could be the claim for asylum. We get a lot of indigenous people asking for asylum because of their race, indigeneity. Political opinion. Did I just cover political opinion? I think I did, but I'll do it again. If you're a member of a political party, if you're advocating political beliefs, if you're supporting a political candidate, if you're marching in political protests, all of those fall under political persecution. If you're arrested and tortured because of that affiliation. And finally, your nationality. Maybe you're a member of a particular group that comes from a different country. Trinidad Tobago has people from India. In addition to their indigenous population, perhaps they're being discriminated against. So if your national background is the basis for targeting you for persecution, again, you can seek asylum because you've been targeted based upon your national membership to another country. The fifth category is the one where we have the most controversy. It's called persecuted social group. And here, if you're a member of a particular group, let's say you're gay or lesbian. In many countries, if you're gay, lesbian, it shows that you will be singled out, discriminated against, tortured, even though the government may have legislation that designs to protect you. And that's actually good news, because if the government has enacted legislation to protect gay and lesbian, that means they've identified you as a persecuted social group. That would make your claim for asylum much, much stronger. In certain districts in the United States, they are trying to say that your gender, your sex, female, for example, is no longer the basis for being a member of a persecuted social group, because being a female is too dispersed, too amorphous, too undefined. I know in the First Circuit, they didn't preclude people who had gender-based persecution claims. The size of the group did not preclude them. The persecuted social group is a vague area. So it could have been your gender. It could have been your sexual preference. It could have been the fact that you were a landowner. In some countries, being a landowner can identify you as being a member of a persecuted social group because landowners are being persecuted. Each country will have unique characteristics that define the outer perimeter of what that social group looks like. And if you fall within that parameter, based upon what's happening in your country, you can use that as a basis for being a member of a persecuted social group. Let me give you some examples that are not members of a persecuted social group because they are used many times and they fail. A common one is from Brazil, that I am a member of a persecuted social group of people who are being threatened with death because we did not pay back our loan to the loan shark. And the loan shark is very unhappy with us, and he has threatened to kill us if we don't pay the money back. So we didn't have the money to pay him back, and we fled Brazil to come to the United States for safety. And I will tell you, 99% of the time, that claim will fail because fearing being killed by a loan shark is not protected under asylum law. There's no what they call nexus. So that would fail. If you come to the United States, you say, I can't find a job. I'm not going to be able to get a job, so I'm coming to the United States. However, if you say, I can't get a job because I'm indigenous and they treat me bad and they've always treated me bad and the police won't protect me because I'm indigenous, now you do have a claim for asylum, not because you can't get a job, but because you're being discriminated or threatened because of your indigeneity. But if it's just because you fear not getting a job, that's not going to work. So that would not be considered a persecuted social group. A third category where people try to say the government is persecuting me because they're preventing me from getting a job. Well, how are they doing that? Well, they don't give us enough money in school to get an education, or they're not protecting our union. What these people fail to realize is they have to prove that the government is targeting them economically by preventing them from getting a job. So if I make it difficult for your family member to get a job because I say bad things about your family member to your employer, the government is interfering with your economic prospects. Now you've got a claim because the government is interfering with your economic opportunity directly. And there's case law to protect that. So the challenge, ladies and gentlemen, under the persecuted social group is to make sure that that group is identified, is observable. In some cases, we say immutable. There's a case called Matter of Acosta. Let's say you're a whistleblower in a country. You become an informant with the police, and you testify in open court against a gang. Well, that testimony and that cooperation will never leave you. It's immutable, and you're always going to be targeted for that. That's one of the key characteristics that make a persecuted social group allowable to be used for asylum. If it's something that you can't change or don't need or should not change, I can go on and on, but I just want to give you a sense of the challenge under the persecuted social group that you have if you're going to use something that's not part of the other four. There you go.
Great. Judge Pappas, you said something really interesting. You mentioned that, for example, for people who are fleeing harm or persecution based on their sexuality, for example, the person is a lesbian or a gay, and they're coming from a country where the government or the country has laws protecting these homosexuals. This actually strengthens their asylum application in US. On the other, oh my gosh, I can hear you. Can you guys hear me?
I can.
Okay. And on the other hand, for people who are gays and whose countries actually have laws against homosexuality, that also tends to strengthen their claim of persecution. So can you talk a little bit more about that?
In both cases, the way it helps the asylum seeker for, let's say, gay or lesbian, is the government has identified them as a social group in society, whether they have laws or whether they don't have laws. If they have laws, they've identified you as a group. And then your challenge is to show that even though they have laws, they're not enforcing the laws to protect you. Because one of the requirements for asylum is you have to show that the government is unwilling and unable to protect you. In countries where they don't have laws, you're going to have to use other evidence of persecution of gay and lesbian people in your society. You're going to have to do the work and show how they are being targeted. There could be newspaper reports. There could be U.S. Department of State reports that show that these people are being targeted. Amnesty International is another group that documents by country persecution of gay and lesbian people. So you would have the responsibility, where there are no laws, identifying these people as a group to show through other evidence that these people are being targeted because of their sexual preference. That is so important if you're going to use that as a basis for asylum. It's one thing for you to say, I'm gay and I'm being persecuted. Well, now you have to prove that people who are gay are persecuted in your country and that the government will not protect you. Because you're going to be asked, did you go to the police and report this? And you're going to say, well, the police are corrupt and they never protect me. Well, you're going to have to really do some evidence, show some evidence why the police are not going to protect you. Do you have personal experience from the past where you tried to file a complaint and you weren't helped? Did you have a family member that ever filed a complaint with the police and they didn't help? Do you have a neighbor? But to say generally, the police are corrupt, they're not going to help me, not good enough. You're going to need some personal proximity to why the police don't protect you. And you'll need some expert documents, peer review articles, or books, or expert declarations or affidavits to show that the police are not going to help gay or lesbian people. The combination of all this evidence, especially in countries where there is no legislation protecting gay, lesbian people, is so important. So that's how you will build a case to identify that you are a member of this group. And that's purely the challenge, just to merely identify that you're part of the group. Then you have to prove what happened to you.
Okay, great. Thank you. Okay, let me try muting you. Somebody suggested when I'm speaking. Let's see how that works. Judge Pappas, no, that's really, I think this is great. I can't hear myself echoing anymore. Wonderful. This was the magic. Okay, so it's really a very interesting perspective, because on the one hand, you made a really brilliant point. If your country has laws protecting lesbians and homosexuals from persecution in your home country, that strengthens your claim, because it shows that it's an actual thing happening in your country, that if you're a gay or a lesbian, then you're going to be targeted, which is why there's even the need for your home country government to come up with the laws to protect you. And then if your country doesn't have laws, or if your country actually has rules or laws criminalizing homosexuality also, it also shows that you are in danger and can strengthen your claims in immigration court. So that's really very wonderful perspective. Again, you mentioned something called nexus. Nexus, it's a big one in asylum. So can you tell us some more about how nexus connects with asylum? What does it even mean in plain language, and then how it connects?
The plain language is connection. The plain language is linkage. It's one thing to say that I am a member of a persecuted social group, or to say I'm being fearful of my membership of a particular political group, or I fear going back because I'm of a particular religion. That's only step one. Step two is now you have to prove and show that you've been actually harmed physically or threatened because of your religion or your race. The harm has to be linked to the protected ground. So on the one hand, you could fear going back because you say, in the past I was harmed because of my because gangs were threatening my family. Okay, gang threat by itself is not enough, and there you would have a problem. Or that someone else was threatening your family because of their religion. But now you have to show that that family membership, in this case, could be a persecuted social group, is also threatening you. But you have to show that you actually were threatened. or that your family membership will endanger you because of that connection to that race or religion. If the linkage or the connection is not there, you fail the nexus test.
Okay. All right. Thank you for that. Okay. Now let's okay. Now let's move on to this. When I mute you, it actually the echo stops. So that's great. When I'm speaking. What are the biggest mistakes that asylum applicants? In fact, no, before we get to that, this was a question I wanted to ask. Out of those five protected groups for asylum, race, nationality, religion, particular social group, which of these were the most common that you saw in immigration court for asylum applicants?
The most common was gender-based and domestic violence. Many times they were not just one basis; it could be a mix of two or three. You only need one to prevail. But most of the cases I dealt with domestic violence from Central America and also South America. I would say the predominant cases were that. Out of the Cameroon, Angola, and Congo area, it was definitely political and religion. Those were the two common reasons for asylum applications. In the Congo, especially, you had political persecution, people that were marching, protesting the corrupt president in those countries. And by participating in those marches, they were arrested, tortured, and on and on. So I saw a lot of political opinion and religion out of the African continent. I saw a lot of domestic violence and gender-based out of Central and South America.
Great, thank you. Tell us some more. I'm actually very interested in the gender domestic violence bit. How does that play out? If you can tell us some more about that.
Well, the first challenge is to prove, well, with domestic violence, the key test here, and I'm not going to go into the case law, is to show that your partner or your husband or vice versa, but it's usually the husband or partner, has tortured you, has beaten you, has tormented you. I cannot tell you of the horrific stories that I've heard. I can tell you that women are treated less than dogs in many of these countries. I'm serious, less than dogs. What they go through. Partners tie them up, burn them, take out machetes and hit them. Not once, not twice. They can't, they're locked up in their own home. They can't leave. They're isolated from their family. As soon as they have a child, all that love disappears. All of a sudden, the man doesn't love her anymore because she has a child. It's called responsibility. They don't like responsibility. So they blame the woman, they torture her. And in addition to showing that you've been tortured, you have to show you couldn't get away from this person. That's a key test, that you could not escape. If you were able to leave a violent abuse or a violent abusive husband or partner, and you didn't leave, it would really hurt your case. So you have to show you couldn't leave. And that if you did get an opportunity to leave and you took advantage of it, you left. You have to also show that the police would not help you. And that's the reason why you didn't report it. So you're going to have to show evidence why the police would be futile, and that's acceptable. The other things you want to show is in these countries, the machismo culture, where women are considered less than dirt and everything follows from what the man does. The man is in charge of your life. You are basically a slave. And there's more than enough documentation to show that that kind of abuse is rampant throughout Central and South America. I'm not talking about the other hemispheres because it exists there. And finally, you want to look at the statistics of female murder. Women are killed for the purpose. Women are killed because they're women. It's horrible. It's called femicide, and the femicide rates are very high. So the combination of domestic violence abuse, partner or husband, can't leave, proof of femicide, futile attempts of going to the police, all make an asylum claim for domestic violence very strong. And I did grant a lot of asylum applications out of Guatemala, Brazil, Honduras, especially those countries, El Salvador, of course. So that's one type of abuse. It's called domestic violence. And then there's the other type that's based upon your gender, simply because you're a woman. And so while the domestic violence part is important, it also overlaps with the fact that you're a woman. And so being a woman who cannot escape a domestic violence relationship in country X becomes another persecuted social group. Um, I may get 4 or 5 descriptions of this type of abuse from the applicant, but it all revolves around being a woman and being a victim of domestic violence. Or if she is targeted randomly in her country because she's a woman, she could be walking down the street and she's constantly robbed, raped because she's a woman. The femicide issue and the gender issue become critical for trying to define that she is now a member of a persecuted social group. And again, those country reports and expert testimony have to show that women are killed and persecuted and abused because of their gender. And so that's another common claim for asylum.
Great. Thank you. So you guys see where the link or the nexus comes in. You have to show that you're being harmed or hurt because of one of the protected grounds. Because of, if the link is not there, then your asylum claim is likely to fail. That's what we call nexus. That link must be there. Obviously, these are all things that if you're working with somebody who understands asylum, they should be able to make sure you establish. Okay, let's move on to, some of, Judge Pappas, you wanted to say something. Let me unmute you. There you go.
It's also important to realize that it's important to know when the persecution started, how many times did it occur, and when did it stop? If you were insulted, persecuted, abused one time, and that was 5 years ago, the chances of you prevailing in an asylum claim are not going to be very good. The longer that you have remained in your country after you were persecuted, the weaker your case becomes. Just keep that in mind. So you're going to be asked, when did the persecution start? Who persecuted you and when? Those questions have to be answered. Go on. Thank you.
Great. Thank you so much. All right. Please tell us about the most deadly mistakes in asylum.
You're married or you have a partner and you both came together as a family. And typically the government will question one family member alone about certain facts. Then they will bring in the other family member, maybe the wife or the husband, and they will answer questions about the same facts, and they give 2 different answers. I can tell you that is the kiss of death for credibility. I'll give you an example because it happened. We had a couple from Brazil, and they were afraid of the, in this case, a loan shark. The case was already dying because it was loan shark, but it got worse when they both testified separately. One said, we left Brazil because we feared the loan shark. We didn't have enough money to pay him. And so we can't go back. And do you still owe money to the loan shark? Yes, we still owe money. Then the husband comes back. Why did you leave Brazil? Well, we feared the loan shark. Do you fear going back? No, not anymore because we paid him back. So that inconsistent, contradictory statements amongst family members is horrible. They didn't do their homework. They have to be consistent with some basic information. So getting caught lying, which is what happens, it looks really, really bad. And that'll derail your asylum application. I'm
sorry, let me say something there before I forget. I'm sure people are wondering, well, if husband and wife are both in court, are they dumb? Why didn't they listen to the other testifier? But the principle of sequestration, right? Tell us about that. The witnesses are sequestered. So all the witnesses are not going to be in the room at the same time because it's like an exam. If you can hear what the other person is saying, when you come, you'll say the same thing. Judge Pappas, tell us some more about that.
That's exactly right. I like your analogy. It's like an exam. You can't hear what the other answers are. That's like cheating. To make sure that your testimony is honest and truthful, we don't want you to hear what the other person's going to say. That's called sequestration. And 99% of the time, everybody's going to be tossed out of the room so we can hear the testimony of individuals who did not hear each other's testimony. And that's when you discover who's telling the truth and who's not. This is also done in USCIS. In New York, we call it a Stokes interview, but I won't go into that. So that's why they're separated. So there's no cheating. That's what we can call it.
Okay, great. Okay. So we're talking some more about the things that could be the death of an asylum claim, dangerous mistakes. You mentioned inconsistent testimonies.
This is a common mistake, and it shows that the people are not being truthful. And I've said this before. All of a sudden, the applicant for asylum produces these wonderful letters of support that detail the persecution that the applicant went through. And all of these beautiful letters are typed on the same typewriter, the exact same typewriter. And the sentences are also almost identical. All the other people had to do was just sign on the dotted line. It shows that you manufactured these letters. They're really not real. You're just telling people, I need your support. Just sign here. We took care of the letter. We wrote it for you. And you see that a lot. And so those will be used against the applicant as not being truthful and being basically, what's the word? Well, just not being truthful. That's a common mistake. If someone is going to write a letter, let them write it in their own hand. Let them sign it. Let them use language which describes their personal experience. If you try to put words in the mouth of the people you're supporting, you're basically going to blow off your head and not get asylum granted. So avoid that common mistake. Make sure that these letters are written by the individual writing them. It could be in their own language. We'll get them translated. That's fine. And prove how you got the letter. Did you get the letter by email? Was it sent to you? This is called chain of custody. We don't want to see that all the letters came to you and then you presented them in court. If they came by post, show the envelope where it was sent to you. Don't lose the envelope where the package or this letter came to you. Prove how it got to you, because the judge may ask you, how did you get this letter? And how you got it can also affect the credibility of these statements. The less handling and the less influence you had on these letters, the better. All you want these letters to show is that they saw you being persecuted. They saw you being arrested. They saw how you were being hit. They saw that you were being verbally abused by X on this date at this time. Everybody's going to have a different experience to show how you were persecuted or threatened. If they're all the same letters, how can that possibly happen? So avoid that mistake. That's mistake number 2.
Let me add to that, Judge Papa. So sometimes we'll have clients who tell their lawyers, oh, my English is not the best. Can you write these letters for me? But as Judge Pappas is saying, it's actually better for you to write it yourself. Those letters are not a test for English fluency or how beautiful you can write. So it doesn't matter. Even better if you have your own mistakes, and we tell them, we have legal briefs that your attorneys will write to support your case. These letters have to be from you. Your lawyer can provide guidance on how, what questions you can answer in the letters, but it's usually better if you're writing these letters yourself. And again, USCIS also looks at some of these things. People will file cases and they have about 3 affidavits and it's the same language. The person likes to use indeed, this goes without saying, and all the letters have the same writing style, language style. Guys, please, these people can see all these things. So, and the judges also notice all these things. So yeah, I just wanted to chip that in.
One more mistake. Unfortunately, notorious do this, and some lawyers who have lost their license have done what I'm going to describe here. Most of you don't speak English. That's okay. And you have to fill out this application called I-589, Application for Asylum. Do not let the lawyer or this non-lawyer, notario or assistant, say, let me write down what I think your fear of persecution will be. You just signed the application. I will write it here. And you have no idea what they wrote. And you don't know how bad it is. I can tell you that certain lawyers or lawyers in New York have been disbarred for doing this. They manufactured the answers. The same answer for different applicants. Of course, immigration sees this. They see the same law firm producing the same story. It will get caught. People lose their license, even if you were granted citizenship. If they go back and find this, they will take your citizenship away. The government is doing that right now, so you have to be very careful. Just remember, write your own story, your own experience, and you will be safe. Tell the truth and you will be safe. If you play these other games, you will pay the price, either with a lost, denied asylum application, or if you were granted a green card or citizenship, later on, they will find out and take it away from you. Don't let it happen.
And let me add to that. The reason why some of these notarios or even some lawyers, and I think the notarios, they really do recycle these stories. And so they've done it. And I tell people they've done it for 50 people. It's really dangerous because the first case will get approved. Even the 30th case could get approved. And so they think that, oh, yeah, we're winning. But sometimes the US government is just building a trail. They are, the time could arise where all the pieces will start making sense. Like we've seen this story before, and then they'll go back and go and connect all the dots. Same story across, you see. And so that's why when somebody wants to sell you an asylum story, you should be very worried because they're not that creative. They are likely using the same story with 100 people. We've seen cases, people have come to our law firms and their cases were denied because apparently even the witness statements, the judges found out that the same witnesses that actually supported their case have supported other cases. And so they lost their credibility and they could tell that the entire story was a lie. So if somebody's trying to sell you a case, they've probably sold it to 500 other people for money. So be very careful with that.
Very good point. Yep.
Okay.
What other questions do you have?
Okay, let's see here. Okay, we spoke about past and future persecution. Let's talk about corroborating evidence. I know we touched on it briefly, but sometimes when it comes to asylum, people are fleeing danger. And so there's the concept that they may not have the opportunity or the time or the luxury to put together an asylum packet with evidence. They are running away from danger. How do such people, how would you say is the best way for them to corroborate their evidence or prove their case, and also just generally corroborating evidence? Tell us more about that.
Yes, collaborating. I like the word, is also used to support your case. That's a more layman's term. Collaborating is basically prove your point. Okay, let's take an example. You were a member of a political party in India, and you were walking down the street wearing your political party's T-shirt, and these 5 guys saw you on the street, and they decided to beat you up because you're a member of that political organization or because you won't join their organization. And the person says, well, they beat me up for a half an hour. And how did they beat you? Oh, they used batons. So these 4 or 5 people were beating this person up with batons, which is a big, heavy stick. And the question to the applicant is, did you suffer any injuries? Yeah. Did you suffer any broken bones? A half an hour is a long time to be beaten up. You're lucky you're alive. So the person's going to testify that they were viciously beaten up. And did you seek any medical care? Yeah, I went to the local clinic or the local hospital or the doctor. Okay. Do you have any corroborating evidence to show your injuries? Do you have any photographs of your injuries? Do you have any doctor's evaluation of your injuries? Did you go to a clinic or a hospital? Do they have a record of you going there? And does it describe the type of injury you suffered? If you have that kind of corroborating evidence, well, then your testimony really starts to gain a lot of weight. Where the corroborating evidence can hurt you and get you caught up in a little lie is that the government's going to inspect what the medical report actually said. Why did the person come here? And the medical report says the person said his ankle was bothering him. But you just testified that they hit you on the head, you were bleeding from the shoulder, they broke your nose. But the doctor's report says you came in because your ankle was bothering you. Sir, can you please explain that inconsistency? So here, your corroborating evidence is going to hurt you because it's inconsistent with your testimony. But as long as the corroborating evidence supports what you're saying, it's going to strengthen your case. So that's one example of where supporting evidence, cooperating evidence is expected if it's available. 2, did you ever call the police to complain? Yes, I did. I went to the police. And did they investigate? No. Did they take down your report? They did. Okay. Do you have a copy of that report? No, I had to leave the country real quick. Okay. Now that you're in the United States, did you contact the police to see if you can get a copy? Because a lot of it's online now. And your answer is, well, I don't know. I don't know how to do that. It's not going to look good because it's reasonably expected that you can still get your police report. So here, the fact that you said you went to the police is not corroborated because it was reasonably possible for you to get a report. So that's where you are expected to have some evidence. If you were in a group of, say, 6 people, 7 people who saw you being threatened, did you get a letter from anybody that saw you being threatened? No. Why not? You said 7 people saw you being threatened. You didn't contact any of these people? Well, I had to leave the country real quick. Okay. Don't you know where any of these people still live? They can't give you a letter to explain what happened to you. And if the answer is no, it's not going to look good. So you failed to get corroborating witness letters to support that you were threatened. So those are examples of where getting cooperating evidence will support your testimony.
Okay, thank you. All right, let me ask this question. Internal relocation. Can you please tell us about that and how it impacts asylum application?
Good question. And you're going to be asked by this because the government has the burden of proof to show that you can relocate. So let's assume you prove past persecution and you still say, I fear going back. The government now has the burden to show that you can relocate. 1, if you are being threatened or have been threatened by the government in your country, automatic, you're not expected to relocate. When the government threatens you, there's case law that says you can't relocate because the government controls the whole country. However, if it's not the government which is threatening you, you have to show why you could not relocate. So maybe you grew up in a village or in a town. You've always lived there, and someone has been bothering you there because of your family membership or because you're part of the political party in that village. The natural question that the government is going to ask you is, Brazil is a big country, millions of people. Nigeria is a huge country. Why couldn't you move to another part of the country? You're going to have to prove and show reasonably why you couldn't relocate. Is it because the gang has networks of people all over the place? Is it because you have friends or family that tried to relocate and they couldn't? Saying that you don't have the economic means to relocate may not work, okay? It's the threat, not the means of whether you will be threatened if you relocate. So you have to prove why relocating is unreasonable. To what extent will you be harmed? Well, if I relocate, the same type of gangs are there and they're still going to bother me. That's not going to work. That's fear of general crime. It has to be specifically targeting you. If you relocate, are they going to be searching for you? And if the answer is yes, then it's really hard for you to relocate, and you can overcome the government's attempt to show that you can relocate. But fearing general crime activity in a country is not enough to say why you can't relocate, because it's everywhere. Not good enough. You have to show why you in particular are being threatened if you move somewhere else. And if you can show that reasonably well, you'll overcome the government's attempt to discredit your argument that you cannot relocate.
Yeah, I was laughing because you mentioned that somebody, if you come and say in immigration courts that you couldn't relocate to another part of the country where you will not be harmed because you didn't have the money or the means to. But then how could you arrive in America? How were you able to relocate to the United States? And I actually read a judge's decision, I believe it was late last year, where the judge said something to that effect, that you couldn't relocate, was from India, but you could find the means to relocate from India to the US to seek asylum, and which is why I was laughing, because that's very interesting.
It also means there are many people who've lived here for many years and they've done very well with their business. They have savings, they have real estate. And to then use the argument that you don't have the money to relocate, not going to work. You've got huge assets here, more than most people have in your country. So the economic argument is not going to really have a lot of weight.
Okay. All right. Let's talk about where some of these asylum seekers go through another country.
Called firm resettlement.
Firm resettlement. That's right.
And this means that if you left your country, let's call it, let's say Greece, and you traveled to Brazil, and you lived there for 6 months to a year before you traveled up the Darien Gap through Central America until you made it to the United States border. But you lived in Brazil for a year. Well, what could happen here? While you were in Brazil, did you work? And the answer is yes. How did you work? Well, I got employment authorization to work in Brazil while I was there. Oh, so you had employment authorization. That would establish that you were firmly resettled sufficient because you got work authorization. Okay. If you get work authorization in another country other than the United States before you came to the US, the government will say firm resettlement prevents you from seeking asylum here because you already had authorization to work in another country. You can overcome that if you show, well, yeah, I did get work authorization, but because I'm Greek, I was discriminated against. My house was burned down and I was targeted because of Greek. I could no longer live in Brazil. That's why I came to the United States. Then you could still pull it off. You can, even though you had a work authorization, the fact that you had to leave because of persecution and discrimination in Brazil still allows you to seek asylum in the United States. If you travel to another country before the United States, let's say you get married in Brazil and you had a child. Under Brazilian law, the fact that you had a child in Brazil gives you the legal opportunity to apply for employment authorization. But the applicant will say, well, I didn't apply for work authorization. I got married, had a child, and then we left. No, under that law, you did have an opportunity. The fact that you didn't take advantage of the law doesn't mean that you escaped the opportunity to be firmly resettled there. So you have to check the law in each country where the applicant stayed to see what economic and resident opportunities they had to legally live there. I mean, if they stayed there for 2-3 days, 2-3 weeks, they're not going to have a firm resettlement problem. But if they were there 6 months or more, working, having a house, they're going to have a tough time trying to claim asylum in the United States because the U.S. government, the Department of Homeland Security, is going to say that person firmly resettled and they are precluded, they are prevented from seeking asylum here. So it's a case-by-case situation. It's very important. It comes up a lot in immigration asylum hearings.
Great, thank you. I think we should take some questions now so that we can wrap up. It's been a wonderful session so far. Guys, if you have not followed the page, make sure you follow the page. Attorney Judge Pappas is also on TikTok and Instagram and Facebook and LinkedIn, so make sure you're following him. George Pappas, you'll find him. Okay. Now, Frank Lucas says, good morning. You know about VAWA? Yes, we know about VAWA. You can contact us for your VAWA needs and we'll be happy to help you. Ayo Elufusan said, hi, Judge. Good to see you, sir. Okay. Let's see. And then, okay, somebody here says this. Sanova M7V. Again, please take notes. This is for general education purposes. We're unable to give particularized legal advice here. Okay. Asylum seeker 1, my child is US citizen. Does it have any indirect positive effect on my asylum case? Because after his birth here in US, in my home country, he also got death threats because he's my son. So Judge Pappas, generally, how does having a US citizen child affect the chances of an asylum seeker in immigration court? Do you think there's any nexus? I'm sorry, let me unmute you. Is there even any nexus?
There's no nexus. I mean, if you have a U.S. child here, it's not going to really affect the asylum case unless the child is very young. And if you are deported, it becomes clear the child is going to be tied to you. So even though the child is in the U.S. and has never been persecuted in your country, with respect to your well-founded fear of future persecution. 2, if the child has no choice but to follow you to this country. And if that child adds extra threat to your persecution because of your religion, your race, then the child's membership in your family does enhance your fear of persecution because the family member is making you more of a target. So that is a situation where the child's presence in your foreign country, if the child is forced to travel back to the country with you, can affect your well-founded fear of future persecution. So yeah, the child could have an impact. Of course, if the child's 18 or 19 years old, they've gone to school here, there's no necessity that that child is going to travel back with you. And even though they're a U.S. citizen, it's not going to affect your particular asylum claim because they're not dependent upon you. They can stay back here. If they choose to go with you, that's not going to help you. Okay. So, but a young child, a few weeks, a few months, 2, 3, 4, 5 years old, who has to travel with you, maybe you're a single parent, they have no choice. Then the child's presence can only magnify your alleged persecution if it's based on one of the protected grounds. So that's where the child could impact your case based on a future fear of persecution, even though the child's a U.S. citizen.
Okay. Great, thank you. So yes, it's not a very straightforward answer. It just depends. Judge Pappas has said it could impact it, and that has to be clearly shown. Okay. There is someone who was asking whether, let me see, the ban. Let me go up. This is Saif Hussein. Any updates on 75 country visa pause? No updates. The pause is still in place. The ban has not been lifted. Then Margaret Buke is on Facebook, says, please be nice to South African refugees. We get persecuted once again. We're not welcome in the US because of the 75 ban. South Africa is actually not part of the 75 country immigrant visa ban. So, but well, Judge Pappas, let me let you speak on that. I'm sorry.
I was going to say Donald Trump is a real fan of South Africa. If you're white out of South Africa, he's ready to kiss your ass. Excuse my French, but that's exactly what he's doing. He's playing politics and racism with the South Africans. He's accusing the majority population of being racist. Donald Trump is accusing the country of being racist. I'll leave it at that. It's beyond belief.
Okay. All right. Let me see if let's see on Instagram if we have any interesting questions. Okay. Ranti Lawal on Instagram says, hi, how are you doing? Do they approve asylum case immediately?
No.
That's an interesting question.
No, asylum is a process, not an event. It's a process. To seek asylum, you have to apply for it. Number 2, you're going to be interviewed if you're at the border without a passport or visa. That process entails an interview with an interpreter. A decision is made. If they think your answers are strong enough to seek relief in an immigration court, they'll let you into the courthouse. They'll let you into the country. And eventually you'll go into removal proceedings. You'll have your first hearing where the judge will want to know what you're applying for. If it's asylum, they'll give you an opportunity to file the application. If you haven't, they'll give you an opportunity to find a lawyer. Then they'll set up another master hearing. It could be 2, 3, 4 months later. It goes on and on. And by the time they see that you filed your application, if they see that it's based upon one of the protected grounds, very important, and they take what's called pleadings. You acknowledge that you came into the country without a visa. You acknowledge that you came in it at a certain time. And if you say yes, 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 then by clear and convincing evidence, the court will find you removable. And then they will schedule your final asylum hearing, which could be in a year or 2 or 3. It's a process. It's not a one-time event. You just can't show up and say, I seek asylum. Please give it to me. Not going to happen.
Okay, thank you. Oh, let me ask this really important question about Judge Pappas, your thoughts on this. Asylum seekers trying to apply for some type of travel document to travel. Number one, whether it's back to their home country or to another country. Oh, let me unmute you. I'm sorry.
If you apply for what's called advanced parole or permission to travel back to your home country, the country that you're saying you cannot live in because of persecution, you might as well kiss your asylum application goodbye. The very fact that you would even apply to go back on the record will doom your application. You're here because you are telling everyone, I'm afraid to go back to my country. And then you have the audacity to say, I want to go back and visit. Are you out of your mind? There's no way that's going to happen. So please don't apply to travel back to your own country, the one you're fleeing from. That's number one. Number two, yeah, you can ask for permission. Doesn't mean you'll get it to travel somewhere else while your application is pending. But remember this, if you get permission to travel with what's called advanced parole, there's no guarantee you will be let back in the country, the United States. It even says it on the approval form. My advice is don't even think of traveling outside the country. Stay here, get your asylum application reviewed and hopefully approved. Then we could talk about traveling. This is not something that you just want to play around with. Every time you leave the United States, especially when you're still in removal proceedings, is really a very risky thing, especially with the current administration, where they're looking to deport anybody they can find. Don't do it.
Thank you. Thank you for that. All right. How about if people are trying to travel to another country, which is not their home country, and once they get their green cards, what does that look like in terms of traveling back to their home countries? Their green cards based on asylum again.
If you have a green card, you can travel in and out of the United States as much as you'd like, as long as each trip is not more than, say, 6 months. Because remember, what you have on your cards is legal permanent resident, not legal temporary resident, permanent. And if they see that you don't really have a residence in the United States, that you really are going back to a specific country all the time, the Border Patrol people may take away your green card if you try to come back, especially after 6 months. However, if you get a green card because you were successful in your asylum application, because you were afraid to live in your country, and then we see that you're going back to your country with a green card, that seems a bit strange. You got the green card because you were afraid to go to your country. You fled fear, but you keep going back. How is this going to harm you? I'll tell you how it's going to harm you. If you apply for citizenship, good luck getting citizenship. They're not only going to deny you citizenship, but they're probably even thinking about taking away your green card based on fraud. Don't do it. If you're leaving your country based on fear, you're not going back unless there's been a change in circumstances. The politics have changed. Things are much safer now. Then forget about what I just said. You can go back to your country and travel as much as you want. But if the nature of the persecution and the fear has not changed, the last thing you want to do is go back there. Don't do it.
Okay, thank you. Let me ask this question. Some of the questions we have no way of answering them. Well, we can answer generally, but we cannot give you legal advice here. Somebody on YouTube, Flavie the Boss, says, are there chances of winning asylum as of now, or can I move my case to another state to buy more time? I really do fear to go back to my home country. I have an upcoming individual hearing.
From shopping. You're looking to move to another state so you can improve your chances perhaps of prevailing. If you actually move somewhere and you've established residency, you can ask to have a change of venue. You'll file a form called E33 with your change of address. It's called a motion to change venue. It'll explain the reason why you're moving. If you have a lawyer, typically they'll file that. And most of the time, the courts will change the date, not the date, the court. Does it mean that you'll have a later date? Actually, you may get a sooner date. You may shoot yourself in the head if you think you're going to get a later date to buy more time. You actually may get a sooner date. So you play Russian roulette when you start moving around like this. Don't play Russian roulette. So that's my answer. And, if you've been working with a lawyer in a specific area, they're familiar with that immigration court and that judge, you would be really, hurting yourself to try to move from that environment where the lawyer knows the judge, the lawyer knows the practice in that court, they've been working on your case, and then you move, let's say, to California. Now you're in a different court. Your lawyer doesn't know this judge, where they may have wanted to appear with you in person. Now they're going to appear by WebEx. You're going to be in one room. They're going to be in another. It's not good. Don't play games with foreign shopping. And unless you've moved for legitimate reasons, maybe you got a job. That's legitimate. Maybe you got transferred. That's legitimate. You're in a different part of the country. All right, you file a motion to change venue. That's different. But don't do it to play games and just shop around for different courts because of what you heard from other people. Oh, that court's more liberal, or that judge is more liberal. There are so many judges out there. You don't know which one you're going to get. Sometimes if you go to California, let's say you lived in New York and you go to California thinking that I'm going to have a better chance because I'm going to liberal San Francisco. Guess what? They may assign a judge for you that's coming out of Texas. The judge is going to be on WebEx. You don't know which judge you're going to get. You may even get the same judge from the court that you're running from. They may assign that judge to hear your case in California by WebEx. So don't do it unless you've legitimately moved. That's different.
Okay, well, thank you, Judge Pappas. You guys, yeah, a lot of these questions, legal strategy, I'll be putting out Judge Pappas's number. We'll put our number there too. You need legal advice, particularized. Make sure you reach out because, again, these sessions are just for educational purposes. Sometimes there are exceptions within exceptions, and there are general rules, there are exemptions. You know, legal strategy sessions are good for those because the attorney can review your case and help you, give you a better answer and strategize with you on what's happening and the best solution for you. Okay. So we have a comment here, Sanova M7V. Thank you so much for doing this. Thank you for your appreciation. Let's take this final question and then we can wrap up. Again, if you haven't followed our pages across social media, AK Poku, make sure you follow. We'll have Judge Pappas again at the end of this month. Immigration court series inside immigration courts, where we go to immigration courts and we get questions answered, questions that are on the minds of many immigrants who may not have ever had the chance to interact with an immigration judge. Okay, now Osei Frankie says, if you have asylum pending case and you want self-departure, what procedure do you go through without detain? So I guess he's pretty much saying he has an asylum case pending. He wants to self-deport. He does not want to be detained. You know, generally, what are some of the things that, or what option is available to such a person?
Let me tell you, first of all, it's a great question. And I will give you a real example. The process is called voluntary departure. Assuming you've had no criminal background and you are allowed or qualify for voluntary departure, that means if you're not detained, you're not in jail, you're not in detention, you're in court, and you ask the judge, I'd like to go back to my country or just leave the United States with voluntary departure. More often than not, the judge will say, okay, you have up to 120 days to leave. I may ask you to pay a bond of $5,000. If you take voluntary departure and you don't leave, you'll be subject to a 10-year penalty of never coming back to the United States, and you will be fined several thousands of dollars. So make sure you leave. And we're going to ask you to present your passport and your ticket to Immigration Customs Enforcement, let's say in 30 days, to prove that you've made efforts to wind down your private affairs. But here's the situation. You have a pending asylum application. By asking the judge to leave, you are withdrawing your asylum application. Once you withdraw your application for asylum, you can never apply for asylum again in the United States. Be very, very careful. I will tell you a real story. Just a few days ago, I read this from another lawyer. Someone from Honduras was in removal proceedings, and the judge asked, do you want to seek asylum in the country? The guy said, no, it's more dangerous in the United States. I'll go back to Honduras. True story. It happened. But to go back to this question, yes, you can ask to leave voluntarily if you qualify. If you do, just be careful because you're withdrawing your asylum application. And once it's withdrawn, it can never be refiled again. That's the answer.
Thank you. Thank you for answering that question. Okay. Well, Judge Pappas, again, thank you so much for your presence here. I know people have more questions, but we're not able to answer everybody's question. I'm going to put our numbers here. You can reach out to Judge Pappas on the number on the screen, and hopefully we're going to be seeing him again at the end of the month. But next week, I will be here to discuss more live US immigration topics. Every Friday, we come live to share updates, answer questions. Judge Pappas, did you want to say something?
Yes, the number is incorrect. It's 828-903-8987.
Okay, let me edit this here. Let's see.
There's an extra digit.
Yeah, let me see if I can edit that. Oop. Okay, let's try this again. Pappas Legal, the number is, let's go.
828-903-8987.
903-8987. Okay, there you go.
There you
Okay,
go.
I'm gonna change that here. Oop. Okay, that's the wrong number, right? No, this is the right one. I'm sorry.
That's the right.
Yes, this is the right one. 828-903-8987.
I'm also on TikTok. I've been on TikTok now for about a month, and it's a very good experience. I do talk about immigration, but I go beyond just immigration. I try to let people know where immigration fits in the overall political agenda of this country, who a real American is. Why is the government using immigration to deflect people's attention from their own problems? There's a whole range of reasons why immigrants are dehumanized, why immigration is politicized. I go into those issues in my TikTok a lot. So I look forward to that.
Okay. Judge Pappas, let me ask you this question that just came up, based on what you were saying. What do you think is the future of immigration in the United States?
Wow. Well, it's going to take a generation, 20 years, to fix the catastrophic events that have destroyed immigration courts and the Board of Immigration Appeals. Immigration courts are going to have to be removed from the Department of Justice to become independent from the political nightmare and interference that you've seen. So that cannot be repaired in 1 year. Even if the Democrats win in 2-3 years, the damage here is severe. It's going to take a generation to overcome the false ideology and dehumanization that the political rhetoric has cast on immigrants. Of course, when I speak, I talk about the value and contributions that immigrants make. The administration here is trying to show that unless you have connections to American history, you're not a real American. They're creating a hierarchy. That hierarchy is white supremacy. And this is horrible. So there's a larger battle going on to repair the damage. The future of immigration, I think the guardrail that will survive is the people. I think it's the people on the ground who are going into the streets today, who now realize that the dehumanization and lack of rights for immigrants finally is threatening them. They now realize it's no longer an immigration problem. And because they are now awakened to this fact, they are on the streets. Even in Republican districts, they're voting Democratic politicians to office. So I do see a huge swing. Of course, the war in Iraq is used to deflect attention from the Epstein files and other horrors here in the United States. American lives are being lost. As American lives are being killed overseas based on these political decisions, the American public is going to be furious. So there's going to be a sea change very soon. It's going to affect immigration in a positive way because we will see how the dehumanization and the false rhetoric that makes immigrants feel unsafe is going to stop. But it's going to take years to rebuild confidence in our institutions. We are being tested as a country as never before. Our democracy is more at risk now than at any time. But I have faith that the people are going to push back, and they are pushing. They push back in Minneapolis, St. Paul beautifully. They're pushing back in other cities. We need more of that. People like me and others who are speaking publicly are fighting against the false narratives, the false stories about who the immigrants are. I mean, the outrageous part of Trump and J.D. Vance talking about the Haitians in Springfield, Ohio during the elections, knowing that they were lying and admitting that they were lying, was accepted by the media. We also have to rein in the false media in this country. People have to learn how to read, do research. But if people work as communities, as brothers and sisters, I talk a lot about that. We are all human beings before we are categorized. We are all human beings. We breathe the same air. We walk on the same soil. Let's not forget that. We are all human beings. And the categorization of people is a political decision that seeks to give power to one group and take away opportunity from another. And immigration has always been part of that. This country has always been picking particular groups to target for any domestic problems. If it wasn't the Irish, if it wasn't the Jewish, if it wasn't the Native Americans, if it wasn't the Blacks, if it wasn't the Italians, if it wasn't the Greeks, the Mexicans, the Brazilians, the Haitians, on and on and on. This is not new. It is not new. But what is new is the general pushback from the public. They've had enough. They've had enough. They've seen how reckless power can threaten not only their safety, but their society and their country. So I'm cautiously optimistic that the public will finally put their foot down and stop this madness. We all need to be part of the solution. Do not be afraid. That's my answer.
Thank you, Judge Pappas. There's this final question that I would love us to answer because it looks like it's a little urgent. This is from Sam Bushra R3U on YouTube. He says, I entered the United States through the southern border in July 2023, and my hearing is in 2029. My family is in danger. Is it safe to request expediting, or could I risk deportation to a third country like Uganda? Oop, hold on. There you go. There you go.
Since you entered the country after November of 2019, you are subject to the government asking you to be removed under these cooperative agreements, and they will say that you can pursue your asylum application in Uganda or some other third country. This only applies to people that entered the country without inspection after November of 2019. If you try to expedite, when you say expedite, you want to move your hearing even sooner, you increase the chances that they will ask for you to be thrown to a different country sooner. Don't do it. Let's see what happens with the politics. If it's 2029, this is what, 2026? I mean, you'll be close to the new election. Let's see if a new administration comes in. In the meantime, prepare your case. Unless it's an emergency and unless you have to leave, don't do it. Leave it alone. Don't advance your case because you are a prime candidate for what's called pretermission. And most of the judges are still granting this request to move clients to a third country to pursue their asylum, even though you've never been to Uganda or some other country. It's a horrible situation. The courts are still examining it. And by the time of your hearing, it may be overruled by the Supreme Court or some other court. It has been overruled by the district court in Massachusetts as recently a few days ago. It's going to go up to the Supreme Court eventually. Judge Murphy in Boston wrote a very strong opposition to this type of what he considers unlawful process of moving people to third countries. But in your case, don't try to expedite your case unless it's an emergency and you have to leave.
Yes, we're getting some questions on, circumvention of lawful pathways and ACAs and pretermission. We can likely cover those later on in our next series. Final comments from Helio Mateo says, what an amazing work you're doing for the communities. Thank you so much for your kind words. And thank you all so much for joining us in today's Immigration Court Series session. Thank you so much, Judge Pappas, for making time to be here. You guys, if you need any immigration assistance, you can contact Judge George Pappas or AK Poku Law. We handle immigration cases throughout the United States. We shared our numbers on the screen, so feel free to go back and look, or you can just Google. You can Google AK Poku, or you can Google Judge Pappas and you'll be able to find our contact. Thank you again, and hopefully we'll see you next week at 1 p.m. on Friday for our live session. Thank you all. Have a great weekend, everyone. Bye.